if we have a meeting and we talk about bad care that we provided, that could get used in a legal case if this patient or their family sues us.
Welcome, everyone, to the Tennessee NAEMSP YouTube broadcast. The legal implications or legal protections offered to quality management programs.
Federal courts generally do not recognize state protections for this kind of work. And there's a new case in Missouri that summarizes all that and once again says we don't necessarily follow state protections for quality and safety work. If an organization participates with a PSO, even if they're sued in federal court, which can happen, I won't get into the details of how, but it can happen, and then all of your work is protected in that federal court proceeding as well.
Well, that's actually an area I wanted to drill down a little bit with you, Kathy. So imagine we've got an EMS provider in Tennessee, and they have a bad outcome. Let's just, stick with Doug's earlier example, an airway problem. So we've got an undetected esophageal intubation. The patient has, brain damage, dies, whatever. The family files suit. Wouldn't that all just be under state law and litigation? How would federal ever potentially even get involved in this?
Typically, it would not in a medical malpractice kind of tort situation. The problem you've got is the interstate aspect here, because if a crew from Memphis goes out to or picks up a patient from the Missouri boot heel, they may get sued in Missouri. And then you've got Missouri law. Federal law typically gets involved where you have arguments of discrimination, Section 1983 cases, or if there's an argument, and we're seeing this in more with our correctional medicine clients at this point, but an argument that the care that the patient received was unacceptable based on race, religion, some other classification that's protected. And if they can make a federal case on that, it will come in federal court. So
Right.
it's out there. It's not going to happen real regularly, but it is one additional reason why the federal protections can be helpful.
Right, right. So we've talked about these patient safety organizations, the benefit they offer, but as I do quality management consulting around the country, I find a lot of differences in the structure and formality of this. Doug, could you kind of tell us a little bit about how these things need to be structured in order to have these protections in place? Because if you just have the quality committee meeting at Starbucks and just having general conversations about this, does that provide the legal protections, or does it need to be a little bit more formal and structured?
Yeah, courts around the country do. It's a great question, Mick. And courts around the country do look, in my experience, at the formality of the QIC, Quality Improvement Committee process, as distinguished from informal reviews, bull session, whatever you want to call it. The formality, the I dotting and the T crossing, this is an area where it matters. Keeping minutes, keeping records. There's an old saying, if it quacks like a duck, waddles like a duck, it's a duck, right? The more that the EMS agency treats that process as formalized, keeps records, keeps minutes, endorses those, or we used to say get a big red stamp, right? Now everything's electronic, but use the electronic equivalent of a big red stamp, privileged and confidential, peer review documentation. Because what's going to happen is if a court is going to review any of these records in a discovery dispute, plaintiff asks for it, defendant refuses, and the court will then review that, what we call in camera. The judge will look at it and decide whether it's admissible or discoverable. And the more indicia of protection and peer review that the judge sees, right, the more that the EMS organization itself treated it as formal peer review, marked it as such, kept the records separate from their patient records, which is Also helpful to avoid what we call inadvertent production. You don't want just somebody reaching into the file and going, okay, here's everything we have, right? So the formality of the process really helps to give courts a basis to uphold those immunities and those protections. The less formal that it looks, then the more likely the court is going to order it to be either produced in discovery or admitted into evidence. So formality matters in structuring a quality improvement committee. I want to add one more point here. I think Kathy made this point, but I think it's really critical, and that is that there's one I mentioned earlier that I would like to see in both Tennessee and all other states specific inclusion of emergency medical services practitioners, EMS agencies, ambulance services, EMS medical directors, medical command physicians. I would like to see the entirety of the EMS system named expressly in these statutes. But one thing that the Tennessee law does that I think even makes a stronger case for participation in a PSO is if a judge is trying to decide whether or not an EMS agency is eligible for these immunities, it can remove all doubt by forming a patient safety evaluation system and reporting to a PSO. That is, no matter what type of organization does it, is protected expressly under the Tennessee statute. So that's one more reason to engage in PSO activities if you're an EMS agency. I think it removes any doubt of the scope of the protections under the Tennessee law.
One thing you mentioned, Doug, that really kind of perked my ears was privileged and confidential. What implications, if any, does that have about who is allowed to sit in on the QI committee meetings? Because sometimes, other outside parties are invited to present and, discuss, the performance metrics, et cetera, or does the committee need to go into special session, if you will, if they're talking about a particular case? What sort of guardrails need to be around this to be considered formal in the event of a bad outcome and plaintiff's attorneys trying to engage in discovery?
Yeah, that's a great question. Oftentimes in hospitals, you see bylaws of a patient, of a QIC or similar organization, similar entity, and that prescribes who can be in on these meetings. And sometimes the organization can bring in a consultant or a contracted agency or organization, such as the kind of work that you were describing that you do, Mick, where with a specific contract and with a policy or a bylaw that says we utilize, a quality management consultant who can participate in our QIC. If you're doing that pursuant to the organization's written policy on how it conducts the QIC, courts are more likely to defer to that protection and extend it to those outside contractors and consultants. If you just bring in people on an informal, hey, we'd like to get your take on this, that kind of thing, it's easy to succumb to that. We just want to get your take, right? That's fine and well, but I think that degrades the possibility of protection as opposed to keeping that committee to those individuals who are formally, members of that committee and the recognized contractors or consultants that committee has documented that participate in its process. So that's a good question.
Yeah, so if I've got my QI committee and say we're going to be looking at some STEMI cases and we want to have, say, the receiving hospital STEMI coordinators sit in on our meeting, and oftentimes they will invite EMS to theirs, right? But for the EMS meeting, how can we include these outside parties? I understand about the consultants, but the people who might routinely be part of it, do they just need to be named as committee members, even though they're outside your organization? Or could you say that representatives of our receiving hospitals or other healthcare entities can be included?
I think there's a strong argument for that. I think it always depends on the structure of the state's peer review protection law. Most would not restrict the protection to, employees of that organization because they do allow for third party participation. I would craft either the bylaws for that committee or the policy that governs that committee in a way that incorporates the continuum of care so that, and you can look up and back, right? So whether it's first responders, pre-arrival, it could be dispatch, right? If we're doing medical dispatch, that of course has a role in this as well. And it could go through the continuum of care to the hospitals. I think that's the holy grail, Mick, because we can look at our own processes, but until we link our care with outcomes and that's really where we need to be pointing. And one other just point to make, I think here that's valid is that if we're concerned, I think there's good arguments to be made for the peer review protection to apply if we structure it and name those participants as part of our committee. Even if there's unclarity, however, lack of clarity in our state law about whether or not that would be protected, I think the benefits of doing that kind of integrated quality improvement along the continuum of care, as you suggest, outweigh the legal risks. If we don't do it and don't improve our care, we're likely to have more episodes of lawsuits and medical misadventure. If we link the continuum of care and really take that integrated look at how well we're providing care, I think we're going to serve ourselves better in the long run by reducing the number of times we have to worry about discovery and admissibility because we hope there would be fewer lawsuits.
Yeah, great points. And Kathy, this seems to be perhaps where there's a big value add contribution of the PSO. Would the PSO be able to assist an EMS organization in kind of structuring these bylaws and processes by which they operate, or is that outside the scope of what the PSOs
Well,
do?
we work with our folks to help them accomplish what they want to do, with the proviso that we can't be legal experts in every state. We don't provide legal services, um, but we will work with them and ask them to bring their own lawyers in to answer specific questions about what it might look like. One of the things I noticed about the Tennessee statute that I think is amazing is it specifically says that one quality committee from, say, an ambulance agency can work with another quality committee, and all of the material that they share remains confidential. That's a big issue in a lot of states because they don't allow that sharing. With a PSO, there's ways, sometimes it's easier, sometimes it takes a little bit more of a dance. But that's one advantage we have is that within the PSO structure, if they don't have that kind of wonderful state law protection, we can help folks to work with other healthcare providers within the continuum so that
And
they can share information.
yeah, so you could end up with a regional QI committee, if you will, that may have the hospital QI committee, the EMS QI committee, the fire rescue, 911, et cetera, all working together at a regional level as a QI entity.
Right, providing that you have PSO participation in all of those, um, and that you've dotted your I's and crossed your T's. As Doug said, this is an area where you can be pretty creative with what you do, but you have to follow the rules that you develop yourself. And the courts will look at that. They will say, okay, here's the policy you developed, here's the program you developed. Did you do what you said you were going to do? And the quickest way to lose protections is not to do what you said you were going to do. So that's the
Yeah.
message we always have for our folks is, we'll help you. We can be creative. The Patient Safety and Quality Improvement Act is incredibly flexible in what it will protect. But you have to think about it up front and then you have to follow your own rules.
Makes a lot of sense. Frank, any other questions come to mind?
I was going to have Doug briefly kind of just specifically mention whether you talk about kind of including your bylaws to say to have the continuum of care be allowed to be brought into the meetings. Do you need to specifically write any sort of carve out about the crew that was involved in the case, or are they included by default, so to speak?
I think usually the committee would have the ability in its governing document to hear from direct participants in the care that they're reviewing, but it would be helpful to expressly state that because we wouldn't presume that those individual practitioners would be members of the standing committee. So you would want to ensure that that committee can hear directly from participants in the care being reviewed.
And along those same lines, Doug, would we want to have something that says the discovery process internally, that say the field supervisors or the management team would get from the people involved in the case, their statements and information they collect? Does that need to be explicitly stated as part of the QI process to be protected?
It should be made clear that that is done through that quality improvement committee. The law directly does name documents, statements, incident reports, other records. So the law automatically sort of expressly extends the protection to those kinds of documents and records if they're done as part of the QIC process. And that's an important if, because the Tennessee law and virtually all others includes an important exception called the original source exception, which means I can't cloak something in immunity or protection merely because I ran it through the QIC process. So, classic example is the plaintiff in a med mal suit is going to be entitled to their medical records. If those medical records show a deviation from the standard of care, which invites liability, I can't cloak those from discovery just by running them through the QIC committee because they're separately available from an original source, right? So, but those records of the minutes of the meeting, the testimony or statements of the providers, the incident report about the malfunction of the equipment or about the issue that they encountered while providing care, that stuff, if done through the QIC committee, would all be subject to the protections of the law.
Very good. Joe, any other questions or thoughts come to mind from you?
The other point that Doug sort of touched on earlier is related to incorporating personnel from dispatch, who in many organizations actually might fall under the auspices of law enforcement, et cetera, and might not even be part of your fire EMS agency. They are law enforcement dispatchers who cover that. So just to make certain that folks, one, appreciate that, and Doug, any additional comments related to making certain that group is included?
Yeah, that's a really good point, Joe. I think, if I don't want to generalize here, but sometimes when we see EMS dispatch housed in law enforcement, we don't always see the medical priority system and, protocol-based dispatching and caller interrogation and differential, response and all of that kind of stuff as part of that. If that center is based in law enforcement, but does have dispatch QA and, recognizes the importance of medical dispatch, I think you're more likely to get meaningful input and information from the dispatch piece of it. If they're not really into medical dispatch, as some law enforcement based dispatch isn't, I don't think most folks would find that to be a very fruitful line of inclusion in their QIC process.
Excellent.
And yes, that was crucial for doing medical dispatch, no matter if it's in law enforcement or a traditional PSAP or if it's an EMS secondary dispatch center. That should be a standard of care. Absolutely.
Kind of to wrap this all up a little bit, Doug and Kathy as well, do you have any particular pearls for our Tennessee members about anything, specific caveats or interesting aspects of the Tennessee law that they should know?
I have a practical suggestion based on our experience with all kinds of providers, and that is many malpractice or professional liability defense lawyers do not understand these laws well. And just as a tip to make sure, if you are defending a situation, to make sure that your defense counsel is familiar with your state or the federal law, and that you've worked with them to make sure they understand your processes and how to defend that. Because you can jump through all the hoops and do it all right, and if your defense lawyer doesn't defend it properly, you're going to wind up having to give stuff up. So that's my last little tidbit.
Well, I'll second that as a former defense litigator, but I would also add that, under the Tennessee law, I think, again, the formality of the process is important. The more that the EMS agency keeps records, minutes, has regularly scheduled quality improvement committee meetings, marks those records as such, peer review protected quality improvement committee documents, the more that the EMS agency itself respects the formality of the process and keeps records accordingly, the more likely it is that the records, notes, and documents of that process will be exempt and protected both from discovery and admissibility. So, we're very formal in following protocols and doing all that kind of stuff. This is kind of a similar thing. Process matters. Structuring it appropriately will pay dividends in protecting the proceedings of those committees.
Very good. Well, I've certainly gotten a lot out of this conversation, and I work in this field, so I really appreciate the insights offered today. We'll go ahead and wrap this up. In the show notes, I'll go ahead and include links to Center for Patient Safety, email addresses for Doug, Kathy, everyone involved, as well as a link to that piece of Tennessee legislation. So thanks everybody for watching.